Hello, it's the Culture Genie. Today, the topic is going to be an overview of the four main Sunni schools or traditions of Fiqh or schools of understanding Islamic Sharia, Islamic Jurisprudence. This video will be discussing their usul, their principles behind making judgments and interpretations and codifying things, and will not be discussing their furu' or the legal judgments made by them, or any codification of rules and laws. This video will also not discuss specific thinkers very much. Instead, we will be talking about the Hanafi school, the Shafi'i school, the Maliki school, and the Hanbali schools as general traditions of law, which started during the 8th to 9th century. I will also be ignoring the Zahiri school, as it's almost extinct and it deserves its own video in the future. Now, regarding these four schools, the Hanafi school, the Maliki school, the Shafi'i school, and the Hanbali school, is that they all began with four individuals: Abu Hanifa, Maliki, Shafi'i, and Ibn Hanbal. These four persons would form the basis of the four schools of jurisprudence that bears their names through a series of various students and later disciples that would use the principles established by these founders and develop various rulings and codifications of Islamic law. It is important to know that these four founders actually were pretty close to each other at the beginning. For example, both Maliki and Abu Hanifa were both students of Ja'far as-Sadiq, who is considered the 5th or the 7th Imam within Shia Islam, and the founder of the Ja'fari school of Fiqh within Shia Islam. It is important to note here that there is within early Sunni Islam actually some overlap between early Shia Islam and early Sunni Islam. They weren't as distinct back during this time as they will become later. Anyway, Imam Maliki became the teacher of Shafi'i, who in turn became later the teacher of Ahmed ibn Hanbal. The founders of the four schools were all interconnected in some ways. And the four schools started out as almost viewing each other as legitimate divergences on the interpretations of Islam. And today there are still people that consider all four schools to actually be legitimate ways to interpret Islam. And historically, between the founding of these schools and today, there has existed a kind of live and let live attitude. But there also existed enormous conflicts between the various schools at various times, and due to various political reasons and historical reasons and reasons of interpretations among various subdivisions of these schools. And some of these have been very bloody, but those will be for another time, as this video is about their principles and fundamental ideas about interpretation. Let us start with the biggest and most widespread of the Islamic schools, the Hanafi school, founded upon the principles laid out by Abu Hanifa. The usul or principles in the Hanafi school. The Hanafi school could be called the school of qiyas, or the school of analogical reasoning, because that is what qiyas means. Qiyas is where you compare a situation found in either the Quran, Hadith, or Sirah with something that happens now, and you try to derive rulings through analogous reasoning, arguing that this case is close to this, or the general principle derived here is just this and needs to be applied here, because they are similar situations or problems. This is the main principle of the Hanafi school, and in fact, Imam Hanafi, or Abu Hanifa, could be said to have been the first to really introduce analogical reasoning in Sunni Islam, which is accepted by most other schools within Sunni Islam, but to a lesser degree. Other principles that the Hanafi school follows is the principle of consensus, or ijma. You should follow what most scholars have agreed upon is the correct ruling, especially the consensus of higher authorities that have already made a judgment. This is not stranger than following the precedents in other legal systems. Then you have juristic discretion, or istihsan, what is viewed as good for a situation. After all, as a judge or as a person involved in making judgments and laws and rulings, you need to see to the betterment of the situation. And you also need to take into consideration urf, or local tradition, as a part in consideration when making interpretations and judgments. After all, it must fit the society, the judgments or the interpretation, without conflicting with basic Islamic principles. And all of these principles are followed in order to reach the ideal of istislah, which is setting things in order and making things harmonize in a good way for the case and context, together with the meaning of the sources. For the greater universal Islamic good, there exists kind of a stereotype about the Hanafi school that Hanafis could argue anything and make anything allowed or halal, and even make things that are obviously forbidden, such as alcohol, to be not only allowed, but even considered almost a virtue to drink. I'm not kidding, by the way. However, Hanafi Islam is actually not that soft as certain stereotypes portrayed, as certain strict Muslim groups, such as the Deobandis, found primarily on the Indian subcontinent, are Hanafis. And historically, there has existed a lot of very extreme elements that are of Hanafi origin, and a lot of conflicts with these elements, especially the early Ottoman Empire that was Hanafi in its legal tradition, had a lot of conflicts due to this. Often due to combining Hanafism with Maturidi theological thought, and in pursuits to centralize power and enforce religious conformity. Next is the Maliki school. First among things that distinguishes it from the other schools is that it actually has another type of canon when it comes to hadiths, and relies heavily upon the Al-Muwatta, which is a hadith collection made by Maliki himself, who gathered a lot of stories that he used for his jurisprudence. The Maliki school still utilizes the other hadith collections, but they have a special place for this one. The second main principle was that Islamic rulings must harmonize with the local culture, or urf, as long as it does not conflict with clear Islamic principles or sources, and traditions that are in harmony with Islamic ideals should be promoted, even if they are not a main part of Islam in themselves. Tradition is not here to replace Islamic law, but to be used as a filter for better interpretations in the local context, and as a way to promote Islam and strengthen Islam, by making rulings that integrate it into the culture. The Maliki school also accepted some other principles for making judgments other than urf, or local tradition. Malik accepted consensus ijma, though he defined consensus ijma as only applying to the first generation of Muslims and the three following generations in Medina. Thus, he did not accept consensus by scholars afterwards to impose upon scholars in other contexts. Thus, every scholar or people that follow the Maliki school should focus upon the local context rather than what other scholars have done. That is to say, as long as they are not in the same context, or can be argued to be in the same context. This means that the Maliki school creates many sorts of parallel systems of local law. A follower of the Maliki doctrine will not be the same in Algeria as he is going to be in Mauritania or on the other side of the world. Lastly, we have qiyas, or analogous reason. And in this case, unlike the Hanafi school, the Malikis do not give qiyas very much weight. They do not think that you should try to draw out something enormously and make far-fetched analogical interpretations. Rather, it's better to just integrate directly and go directly to local traditions and argue from greater Islamic principles, rather than drawing far-fetched comparisons from very specific cases. Of course, qiyas is still used and is to be used integrating local tradition and making it better for the society, making istihsan, juristic discretion, very important. However, juristic discretion in this case is focused upon greater society and the greater local society, rather than the best scenario for the specific case, for the specific persons involved. The spiritual betterment of the society is prioritized. And now we go to the Shafi'i school. The Shafi'i school can be considered the school of consensus or ijma'. Consensus among the Shafi'is means the consensus among all the scholars of Islam. Actually, Shafi'i himself argued that all the scholars of Islam, or all the more agreed upon higher scholars at least, should meet each other in order to reach consensus upon rulings and judgments and what to do in certain situations. Shafi'is usually envision a kind of flat hierarchy among scholars, where consensus rules and decides what is correct. The consensus among the Shafi'is is also back in the past, as well as in the present consensus. So they are very concerned with upholding a tradition of consensus and coherence through the ages. And this consensus precedes everything, almost, within the school. For example, the validity of the hadith is based upon ijma' consensus, and not only the narrative chains in themselves. In other schools of jurisprudence, you usually argue for the validity of using one hadith by the chains of who said who, how reasonable is this, what has others said about this event. But this process is usually an individual discretionary choice. In the Shafi'i school, it is not. Rather, it is based upon previous consensus about what is correct and what is not correct. And they also have inherited a lot of previous rulings, more than the other schools, from their founder. Shafi'i was one of the first to actually write a rather complete rule book or law book, a risala, a very extensive, for its time, book of fiqh that details a lot of rulings and judgments. Now, of course, not everything can be directly derived from consensus. So you have to use qiyas, analogous reasoning, in order to argue that something is close to something that either exists within the consensus or directly in the sources. Personal juristic discretion, or istihsan, as making the best of the situation, should only be done as a last resort. This is in order to preserve the consensus and coherence of Islamic law. Local traditions, urf, is completely rejected within the Shafi'i tradition, as something that should be taken into consideration. Likewise, istislah is only in order to better implement the will of God as defined by the consensus, not to better society or any other goal. The last and next school is the Hanbali school. The Hanbali school is more defined by what it rejects rather than what it accepts. Hanbal rejected almost all secondary principles of fiqh found in the other schools of thought, in favor of direct literalist interpretation, with very strict criteria of which sources he considered to be valid. This meant that the Hanbali school of fiqh traditionally has used very few hadiths, and only the strongest hadiths, according to their very strict criteria of being trustworthy. The Hanbali school also, with Hanbal, rejected urf as local traditions to be something that should be considered. Istihsan, making the best of the situation, should also not be considered. Even qiyas, analogous reasoning, should not be applied, according to Hanbal, though later Hanbali scholars did introduce it somewhat. But the ideal is that only cases that are exactly the same as what is found in the sources of the Sunnah and of the Quran should be accepted. Of course, some degree of analogous reasoning does come into this when you begin to discuss what is exactly the same or how close should it be in order to be considered the same case. Hanbal rejected consensus, ijma', except the ijma' of the first generation of Muslims. That is to say, if something is agreed upon by the sources, by people in the sources. Hanbal saw the idea that scholars should choose and have a consensus of what is right or wrong, and that this should be followed in interpretations of matters of Sharia as being akin to scholars setting themselves up in place of God. Instead, Hanbal proposed more personal and individualistic interpretation based upon strict criteria. Though later Hanbalis have also adopted at least some tradition of ijma' or consensus. The rejection of other principles of fiqh, such as istislah, making jurisprudence for the public good, making new rulings for new things outside of the direct interpretation of the Islamic sources, was rejected. And the focus upon having a very stringent definition of what is a valid hadith to use, together with accepting only direct literalist interpretation, means that the Hanbali tradition is extremely strict on certain things, generally, but not as all-encompassing as the other traditions in some ways. This also goes into another subject. Despite this being a tradition that has been adopted by rather extremist elements today, in various ways, both directly and indirectly, it would be wrong to say that the Hanbali tradition historically has been the extremist tradition within Sunni Islam, though this is a matter for another video. Now, I think it's a good idea to go over all the differences and similarities between these various schools using a chart. As you can see on this chart, the schools are listed from Hanafi to Maliki to Shafi'i to Hanbali, and to the sides are the various principles and special considerations that are important to discuss with regards to these schools, and the differences between them. The first subject is if there exists a difference in secondary sources between the various schools, when it comes to sources to use when making judgments with regards to law. The Hanafi tradition more or less accepts almost all the hadith collections as being valid, at least the 6 big ones, depending on context and subject matter. The Hanafi school leaves a lot of individual discretion to which hadiths to base a judgment upon, though there does exist usually a kind of standardization based upon some authority about which hadiths to use within the various sub-branches of Hanafi fiqh. Next is the Maliki school. Pretty much the same as the Hanafi school in that they can use pretty much all the hadiths, but it's very dependent upon local customs. And they also have additional hadith in the Mutawatta that they tend to use more than others. Regarding the Shafi'i school, they have all the hadiths. However, for a process of consensus, they decide which hadiths are considered valid or not valid. It is not only a process of looking at the chains of narration, but certain hadiths must also go for a process of being accepted as being valid for a certain type of judgment. It's not up to the personal or individual logical discretion. Rather, there exists a standardization of which hadiths to use based upon consensus. Then we have the Hanbali school, which has a very limited number of hadiths that are used in the collections due to very strict criteria of which types of hadiths are to be considered true or not, and thus valid for use. Next topic is if qiyas or analogous reason is allowed, and to what extent. In the Hanafi school, yes, it's the primary type of principle that you use in order to make interpretations. In the Maliki school, qiyas is to be used as a last resort when there is no other source that can be used for making an interpretation. Pretty much, qiyas is only used due to pragmatism, to fill voids that exist and need to be filled. And the Shafi'i school does allow qiyas, but it must follow the consensus and be subordinate to it. Individual use of qiyas can only be used when there is no consensus that goes against it. Thus, individual qiyas is only there to fill the void where consensus is lacking. The Hanbali school rejects qiyas in favor of direct application of the sources on a ruling. If a direct application cannot be found in the sources, then there should be no ruling or interpretation based upon qiyas. However, deciding what is a direct application or not does require at least some use of qiyas or analogous reason, so it did get integrated into later Hanbali scholarship, though Hanbal himself would have rejected it outright. Next is ijma or consensus use as a principle to derive rulings. Among the Hanafis, yes, they use ijma or consensus. Though it's not the only principle, it is important for case law. In the Maliki school, yes, they use it, though it's along local traditional lines of Maliki schools. Various versions of the Maliki schools have their own versions of consensus. And also, the first 3 generations of Muslims are considered especially important to derive judgments from their consensus. In the Shafi'i tradition, yes, it's the primary principle, and the Shafi'is try to have consensus among the scholars of the Shafi'i school in everything. The Hanbali school rejects ijma as a source to make judgments and interpretations, though they do recognize the consensus of the earliest Muslims around Mohammad. So when Hanbalis speak about ijma, it's not the consensus of scholars, but rather the consensus of the people around Muhammad, as they are seen as the perfect people to emulate in all the schools, but especially in the Hanbali schools. That is what ijma refers to. Then you have orf, or local tradition, and customs, and if they should be considered or taken into consideration. In the Hanafi tradition, yes, but you should try to apply universal standards in your rulings, meaning that local tradition is just one factor of many. In the Maliki school, yes, urf is the primary principle used there, but only as long as it is not against what is written in the sources. But ideally, you should try to integrate local customs and local traditions and ideas with your interpretations of the sources. Both the Shafi'i tradition and Hanbali tradition reject consideration of local customs, generally, because there are always exceptions to these things. The next topic is istihsan, or judicial discretion in order to reach a higher good when making judgments and interpretations on an individual level. In the Hanafi school, yes. In the Maliki school, yes, and often with regard to the local society's betterment. In the Shafi'i tradition, it is a last resort when there is no consensus, and the Hanbalis just outright reject it, as the goal is to literally follow what is written in the Quran and Sunnah, with no other goals besides that. The next is if it's okay to do individual reinterpretations of the sources when you make various types of judgments. This is called ijtihad. In the Hanafi school, yes, on a case-to-case basis. It's important that the intention is good and that the consequences are good. Though it's important to note that you should still have a basis in the Quran and the Sunnah. The same is also true in the Maliki school, though they have a greater emphasis on conformity to the social norms of the society, so that it accepts the judgments and the Islamic way of living. The Shafi'i school does kind of reject ijtihad on the individual basis, though they permit it on the basis of seeking ijtihad through ijma or consensus. Thus, it is collective reinterpretation based upon consensus judgment. As for the Hanbali school, no, on a larger scale, as you are not supposed to reinterpret the sources, but rather just interpret them directly and apply it. Though, yes, on an individual level, with regard to finding the truth of the sources, as you are allowed, as long as you are stricter than certain criteria, to actually disregard certain sources. And thus you can do ijtihad by disregarding certain hadith, by for example claiming that there are not enough evidence for these hadiths to be strong enough for legal use. And this can be viewed as a kind of ijtihad through disregarding certain sources rather than reinterpreting them. Though the Hanbali school requires you to have principles and standards in reaction that are even stricter than those of Hanbal if you are to apply this kind of thinking. So it's not free for all reinterpretation through reaction. And the intention is still to come close to true Islam, and not any secondary objectives, like fitting into society or the like. At least officially. Now we come to the next subject, which is how are these schools traditionally organized? The Hanafis, at least in relation to the other schools, tend to be more centralized, and often having a kind of top-down structure to their hierarchy of scholars. Though examples of decentralized structures have also existed and has been almost as common as centralized structures. The Maliki school tends to organize itself into several paralystic local structures. So they are decentralized in the sense that the Maliki school is not the same everywhere, though they tend to have rather strict hierarchies locally among each other, but not always, since there are a lot of local exceptions. In other words, you have one hierarchy there and one other hierarchy over there, acting and being structured differently. As for the Shafi'i tradition, they prefer, or rather have an ideal about a rigid, consensus-based, flat hierarchy of scholarly peers. As for the Hanbali school, Hanbal himself envisioned a more personal, individualized kind of decentralization, where every scholar worked by himself in order to find God's way and to implement his way. In practice, it usually resulted in rather centralized, top-down structures. However, this centralization and top-down structure is in practice. In theory, the ideal is a rather personal and individualized decentralization in jurisdiction and application of jurisprudence. Now to the last part of this chart, if there is some sort of special consideration or trait that could summarize these schools. In the Hanafi tradition, it is istislah, or common good, that is the driving principle. Istislah also exists in the Maliki school, but there the focus is more on integration of local customs in order to reach the greater common good. And it is this integration of local customs that is the defining trait of the Maliki school, as they go the furthest in it. Istislah also exists in the Shafi'i school, but there it's not the same, as it is not related to the kind of utilitarian and intentionalist thinking that you can see in the Hanafi and the Maliki school. Instead, it's a term used for certain principles established through the consensus tradition on the validity of hadith and interpretation of the Quran and of what the religion calls for. And this could be said to be the main trait of the Shafi'i school, this focus upon consensus and the precedence it sets for interpretation and judicial rulings. And if the Hanbali school has one defining trait, then it would be direct literalist personal interpretation. Now this might come as a surprise, but the Hanbali school was actually very focused upon the individual and personal relationship to the divine, at least in the beginning with Ibn Hanbal. And it's important to know that Sharia and Fiqh understanding of Sharia is actually about more than just legal terms. It's also about the way of God and the personal as well in relation to God. And it is here that Ahmed ibn Hanbal's school really distinguishes itself as having a concrete focus upon this, in that it's the direct literalist interpretation on the personal level that is important, not the hierarchy or consensus of previous scholars, or greater society. Now, of course, the Hanbali school does have a lot of rules regarding greater society, but it's not for the interest of greater society, but for the relationship to the divine, as interpreted through direct literalist interpretation by the individual. And that pretty much wraps it all up. Sure, there are a lot of other things I could have added and I could have spoken about, but for this rather short overview, half an hour, but short nonetheless, I hope it has been informative. And if you have questions, please post them, because I know that this is a very intricate subject with many complexities. And I want to know if something was not clear, or if you thought that something should have been more elaborated upon, so that I might answer that in the comment section or focus upon it in future videos. Please do subscribe, as it would help the channel spread awareness about the humanities. اشتركوا بالقناة من فضلكم.